Record button, Katie. There we go. As far as introductions go, my name is Nicholas Peasley. I'm one of the staff attorneys at Oregon Realtors. I had a hand in drafting the forms, and so I kind of was a part of making these things happen. I'm doing the training on the tenant occupied properties today, forms today. So this is all the stuff that has to do with when you've got a tenant on the property. This is separate from the occupancy agreements. So if you wanted to come in and learn about how the buyer and seller occupancy agreements work, we're going to cover that later, but it's a whole different ball of wax because it deals with its own special rules and rights and the Residential Landlord Tenant Act and a bunch of other stuff. We'll cover elements of the Residential Landlord Tenant Act today, but most of it is going to be about the actual tenant occupied property forms, which is sort of how you have a tenant who's a third party in the property as opposed to when the buyer or the seller becomes a tenant. We got 10 o'clock, so let's get this show on the road. So this is how to navigate tenant-occupied properties with the Oregon Realtors forms. We're going to cover a handful of things today, specifically forms 4.2, 7.1, 7.2, and 7.4. Those are the ones that we're going to be covering. We'll get more depth on that, and the goal is that you'll wander away from this understanding how these forms work, how to use them, and what their use case is, and kind of what the fundamental pieces of it and why the decisions that went into making the forms what they were. So let's start off with, I have my mouse in the wrong place, so I need to be able to, okay. Tenant occupied property. So this first little bar here, lines 40 and 41, that is from the residential landlord or residential purchase and sale agreement. Section 11 is about tenants. The first question that it asks in that section 11 is the property currently tenant occupied? You can answer yes or no, which is yes, there's a tenant on the property, or no, there's not a tenant on the property. So if the property is tenant occupied, it's a property that has a tenant in it. The seller is leasing the space out to somebody. This can be a various set of tenants. You can have residential tenants, they can be commercial tenants. In theory, you could be leasing out your parking spot or something like that. That's technically a tenant that you're dealing with at that point. In the Oregon Realtors forms, we present you with those two options. Yes, there's a tenant, or no, there is no tenant. If you answer yes to that question, yes, there's a tenant, then you have two options as well. Is the seller supposed to terminate that tenant as a part of this agreement, or is the seller not supposed to terminate the tenant as part of this agreement? If the seller is terminating the tenant, that means they're sending a notice that says, tenant, you got to be out within, by the end of the 90th day or the 30th day or whatever it ends up being for that, you would use form 7.1, and we'll go into that. That's a tenant vacancy addendum. If the seller is not supposed to be removing the tenant, you say, yes, there is a tenant occupied property, but no, the seller is not issuing a notice to the tenant. What that means is that you're going to have a tenant that stays on the property past closing. That makes the buyer the new landlord once closing happens. We have form 4.2 for that. That's the investment addendum. So investment property addendum, it's the way of kind of providing all that specialized landlord information over to that new buyer. It makes sure that there's assignment and assumption. It makes sure that the buyer gets the various statements they need to know about the lease and they can approve the lease and whatnot. But it also does, when you have an investment property, not a vacant property, or a tenant vacating before closing, the buyer is becoming a landlord and the parties understand that at the onset. So use this section 11 to indicate what you're doing with those tenants, whether or not the buyer is actively and intentionally becoming a landlord, or if you're going to be terminating that tenant. If you do say, yes, we have a tenant, you have two form options. This is what we're talking about. Form 7.1, vacancy addendum. Form 4.2, the investment property addendum. 7.1 is the vacancy addendum. It's used when the tenant is present in the property and the parties are planning for the tenant to be removed at some point after the closing day so that you're going to have the tenant out. This is not necessarily the tenant is out by closing. That's what the vacancy addendum is. We'll get there. In some cases, if you have a closing date that's 30 days out, but you live in Portland and you require 90-day notice, you might have something where you give the tenant notice, the seller gives the tenant notice, but the buyer takes over the landlord role partway through that termination notice, and then later on the buyer, the new landlord, is the one that terminates on that property. This document provides the buyer with the lease information and explains what happens if the tenant refuses to move out. That sometimes happens. There's a process for that. It's not an exceptional process. It's basically, well, buyer, you're a landlord now, so rights and obligations of the landlord are what they are, or you terminate the contract because the tenant didn't move out. It also assigns the lease if the tenant is not moving out or refuses to move out by closing. So we have that language in there. Form 4.2 is the investment property addendum. This is used when the buyer is taking control of property with a tenant inside and they're planning to use it as a passive income stream, not as a residence. So the buyer is not moving into the property, they're just using it to generate income. It provides the buyer with a list of optional disclosures of various things they can ask about. I'll highlight a handful of them, but there's quite a large list of things that the buyer can request as parts of due diligence for this investment property. And it also provides a chance to back out if the lease isn't what the buyer wanted it to be. So if you're looking at the lease and you're like, this is $50 a month, are you crazy? This is nonsensical. I cannot possibly take this property because it is not cost effective. The buyer does not have to buy that property anymore. There can be processes they can negotiate. They can switch it over to where they're going to terminate the lease, something like that. But essentially, it provides disclosures that allow the parties to negotiate with more depth at an early stage in the process rather than after you've closed when the buyer has to figure it out. We're going to start by talking about Form 7.1, the vacancy addendum. This is kind of the classic document that you'll usually use in the residential context. So Form 7.1 is what we're looking at. Start with Section 5 of Form 7.1. That's not what I have on the right-hand column. Right-hand column is ORS 90427. This is how you terminate tenants under Oregon residential landlord-tenant law. Form 7.1, Section 5, the exact quote is, this form is used for use when the buyer is purchasing a tenant-occupied property and a termination notice will be issued to the tenant by seller under ORS 90.427. Buyer and seller must each consult qualified experts to determine, 1, if the termination is lawful, 2, if the property is termination timelines and if the proper termination timelines and procedures were followed, and lastly, you're going to determine the required relocation assistance amounts if they are required. So there are instances where you'll have relocation assistance that is required. In some areas, it's more restrictive than in others. I believe Portland has a much more readily usable relocation assistance provision, but generally the laws will apply. In this provision, this Section 5, we also say, look, buyer and seller's agents are not experts in landlord-tenant law. They will not be providing expert commentary on leases. They will not be telling you how landlord-tenant, like ORS 90 works. They'll be helping you sell property because that's what their license allows. They might help with the process if you want to do management afterwards and they have a management branch, or they can refer you to property managers. That's great. But do not, the buyer and the seller, by signing the agreement, are recognizing that they are not relying on statements by their real estate agents as to how lawful the termination of a tenancy is. You know, if they say, hey, can I terminate the tenant in 90 days? And the realtor goes, yeah, it sounds about right to me. That's not a legal opinion. That's just the realtor saying it. So it's not, this form is not substitute for legal advice. If the clients really want to know stuff about like the legality of a termination or something like that, have them consult a lawyer. We're going to talk a little more depth about what this does technically is it limits the use of Form 7.1. It basically says this is only supposed to be used for a small subset of situations when you're terminating a tenant, and when the for the sake of 9427, which is without cause terminations. If you have cause for the termination, the tenant failed to pay rent and things like that, very different process that's going to be used. But in these instances where you're terminating a tenant without cause, basically because someone's moving in, we use a different set of rules. Why do we limit the use of Form 7.1? That's because termination under Oregon is a super complicated process. Under Oregon law, it's a complicated process, and it's oftentimes dependent on the lease itself and how long the tenant has been there. If it's a fixed term lease, you'll have some rules. If it's a month-to-month lease, you'll have other rules. If it's a week-to-week lease, you have more rules still. And the length of time that the tenant has occupied the space is going to change how you terminate as well. If they've been there for more than a year, then you're going to have certain termination rules. If they've been there for less than a year, you'll have other termination rules. Up on screen right now, we have would you kindly email a reply of this webinar to us? Oh, I'm sorry. I can slow down as well. I do apologize on that. I'll slow down, but we will also, I believe, put the recording somewhere. Katie, if you could answer that one in the meantime. ORS 90427 is the way that you terminate a tenancy without tenant cause. So tenant cause is usually something along the lines of the tenant violated the lease, or the tenant failed to pay rent, or, for example, one of the other tenant causes, if one of your tenants is sexually assaulting another member of that same household, there are ways to evict one tenant and not the other. This 90.427 is the ways to evict a tenant without any of those other named causes under Oregon law, and they're very distinct sets. So for example, 427.2, subsection 2, if the tenancy is a week-to-week tenancy, you could terminate by giving written notice 10 days before the termination date. That's the week-to-week set. So if you, for example, are dealing with a tenant on the property, you're a buyer who wants to buy property, and there's a week-to-week tenant, you can say, hey, seller, can you give them notice? And this is the rule that apply, 10 days notice, at least 10 days notice before you terminate. Great. If it's a month-to-month tenancy, there are different rules. In the month-to-month tenancy context, if the tenant is getting terminated and they've been there for less than a year, At that point, you need to give them 30 days notice prior to the designated termination date. So if, for example, if you're a buyer that wants to purchase the property and you say, seller, I want to buy your house, but I don't want the tenant there. Can you terminate this tenant? The tenant needs 30 days notice at that stage before they are terminated. Now, this is going to modify periodically, and there are things that'll amend and adapt that. But you need to give that notice for like 30 days in these month-to-month, less than 1 year contexts. Now it gets more complicated. If you have a fixed term tenancy, that's where you don't say you're renting the property from month to month. You just say you're renting the property until June 3rd, 2026, something like that. You fixed the term to a certain day and time. Very different rules apply. If you have a fixed term tenancy, the landlord can only terminate the tenancy during the fixed term for cause, which we don't have here. The not for cause reasons that a landlord can terminate in those cases are only allow the landlord to terminate at the fixed date. So if you have a fixed tenancy that goes till June 3rd, 2026, the buyer can't terminate that tenant without cause until June 3rd, 2026 has happened. You can give notice beforehand that then says, hey, heads up, on June 3rd, we are terminating your tenancy 3 years from now. And you can do that, but the buyer needs to be aware they can't get that tenant out until much later on because the term has been fixed. Fixed term tenancies create serious issues at times because it does lock you into a very set piece of time, which is why most of the time you should see landlords doing month-to-month tenancies. That tends to be the easiest one for a landlord to terminate, or the one that's the most kind of standard or normal. Fixed term tenancy will create some issues for you, and be aware and read over ORS 90.427 to understand fixed term tenancies a little more if you do have one that pops up. But that'll modify how you terminate something as well. The last one, and this is kind of the usual use case for Form 7.1, is if you have a tenancy that is month to month, but the person's been there for more than a year, you need to give them 90 days notice, and you can only terminate them in those instances where they're doing month to month and they've been there for more than a year with a certain subset of specialized rules. One of them, specifically subsection 5D, allows the landlord to terminate if they've accepted an offer to purchase the dwelling unit separately from another dwelling unit from a person who intends to occupy the unit in good faith. So, for example, seller says, buyer, here's my house, it's got a tenant in it. And the buyer says, great, I want to buy it and I want to live in that house. Wonderful. Landlord has now accepted an offer from a third person who is intending in good faith to occupy that dwelling unit as their primary residence. At this point, as long as the landlord, the buyer, the seller has given the tenant notice that they received this offer within 4 months of getting that offer, you can terminate the tenant with a 90-day notice. So you have to give the tenant notice that you got an offer, and you have to give the tenant notice that their lease is going to end. Those two need to exist. This is the usual use case of 7.1. If you have a tenant who's been there for more than 90 days, this is why this form exists in large part, because you then have a 90-day notice requirement and some pretty distinct rules that have to be followed. There are a couple other uses for Form 7.1. It, for example, indicates whether a buyer is occupying the home as a primary residence, which is what triggers that ORS 90.427.5D subcategory allowing the termination right. It allows you to indicate whether there is relocation assistance that the buyer pays. In some cases, the buyer can pay relocation assistance. They don't have to. The seller is technically the one that does that, but you have the option in subsection 8 of Form 7.1 to say that seller will pay any relocation things. Parties agree that buyer will reimburse seller for the relocation assistance. Yes, no, the buyer doesn't have to reimburse. That's not a requirement, but if the parties agree on that, then this is somewhere you can specify these things. I've seen issues where evidence of offer has been debated. Is written notice of the offer sufficient? Written offer of the notice should be sufficient. If you have a written notice that has been signed by both parties, for example, the offer from the buyer that has been signed by the buyer and then signed by the seller and the buyer has it, that shouldn't be I mean, people will take things to court frivolously, but that would be about as frivolous as a case could go, because that proof of an offer is as absolute as the law requires. I don't foresee there being any instance where if you have an oral acceptance of a contract, then yeah, you'd have a problem there, because the statute of fraud applies. Statute of frauds applies, and you need those written contracts to purchase real estate to be in writing. But as long as you've got proof that you have a contract that has been signed by the buyer and the seller, and they've agreed to purchase real estate, you've got the evidence you need under law. I see Cindy says if an owner owns more than 4 properties, uh, but through different LLCs, do they have to pay the tenant to move? That is a fine question. So this is in reference to this ORS 94276C, which is relocation assistance, which is it applies when a landlord owns more than 4 dwelling units in Oregon. The landlord must provide 1 month's rent at the time they deliver the notice of termination to the tenant. Generally, if the LLC owns those properties, that is not something that is considered owned by that landlord. So relocation assistance, and this is something where check your city's rules because it could be more restrictive. If you live in the Portland area, for example, I believe relocation assistance has different rules that are up and above ORS 90. But in general, the reason why you'll see many people put their various rentals in LLCs, this is one of them, is it separates the ownership out into various places. So Cindy, my understanding is that no, you would not be paying relocation assistance if you don't, the landlord is the LLC for one of the businesses, and then the person themselves owns 2 other properties. Those are separate owners at law. Stephanie said, sorry if I missed this or if you're going to get to it later, but if the buyer is not planning to occupy as their primary residence, can they still terminate the tenant's lease with the 90-day notice, or are there different rules? If the buyer does not plan to occupy the premises and the tenant has been there for more than 1 year and it's a month-to-month tenancy, the buyer doesn't have a rule that allows them to terminate at that point. There are some subsection rules in ORS 94275 ABC, not the D category, but those are pretty cabined in restricted areas. In general, it is very difficult to upend a tenant who's been there for more than a year on a month-to-month lease unless you have a good reason, and usually that good reason is undergirded by buyer moving in and living there. If the buyer just wants to kick the tenant out to put a different tenant in, the law does not smile well upon that buyer if they start the process for termination. So Stephanie, the answer to your question is generally different rules will apply, but in those cases, your buyer is probably going to be looking for something more along the lines of a for-cause reason, failure to pay rent, for example, use of drugs on the premises, that sort of thing, keeping pets on the property that can, when you're not allowed to, that sort of thing can cause a right of termination. If relocation assistance doesn't apply, do you leave blank or check yes? If relocation assistance doesn't apply, you can check, you can leave it blank. In general, it's better to have something like this agreed to even in those cases though. For example, with the LLC, if you say like, well, I'm pretty sure this is not the case, and you're in Portland and it turns out you do have to pay relocation assistance, you want a place in mind here where you can say yes or no if you suddenly find out, whoa, oops, sorry, relocation assistance does have to be paid. Is buyer reimbursing or not? So for the question by Anonymous on that one, yes, you should probably fill it out one way or the other because this is generally with the if applicable, relocation assistance will be reimbursed in the following ways. The default stance on this would be to check the no box because usually buyers aren't reimbursing sellers for relocation. That's something that's just done. What if the landlord has a 30-day notice written in their lease? Okay. If your landlord has a 30-day notice written into the lease and the tenant has been on a month-to-month lease for more than a year, it doesn't matter what your lease said at that stage. Follow Oregon law at that point. Residential Landlord Tenant Act will usually supersede because it's generally written in to protect tenants, broadly speaking. So Aaron, what I would say is if your lease says you can do a 30-day notice, still adhere to the Oregon laws because you're going to get into some really, really finicky arguments that require a team of lawyers to answer if you actually do get into an argument with that tenant. So even if your lease says I can terminate within 30 days, if it's a residential lease, follow the Residential Landlord Tenant Act. If it's not a residential lease, if you've got a commercial tenant or an agricultural tenant, something like that, where they're running a business on the property, different rules apply. That's under ORS 91, which is all the other leases. For residential leases, we have additional protections and coverages, and that's special rules that apply. So Aaron, to answer your question, if your contract is in place and it says we're allowed to violate Oregon law, please don't violate Oregon law. Just follow on with ORS 90. Other uses of Form 7.1, for example, providing lease documents. It lets you set a termination notice date and create mandatory notice if things go wrong. So, for example, this provision, Section 6, seller will provide buyer with a copy of the rental agreement between seller and their agent or their property manager, whoever it is, and the tenant. This lease needs to be given to the buyer within 2 days of mutual acceptance. So this is a copy of the lease. And you should redact personally identifying information other than the tenant's name. So if there's something in there that says, tenant came from Minnesota originally, and or they've got a letter that they sent in or something like that, or they've written something in the margin, redact that information if it identifies more about the tenant than just their name. We've been very restrictive on personally identifying information in these cases because the kind of direction of law is being more restrictive and more penalizing if someone does send personally identifying information in a way that they weren't supposed to. So we're erring on the side of caution with relation to all kind of personally identifying information or information that can identify people. Teresa asks, can you send us the Residential Tenancy Act? That is ORS 90. If you look up ORS 90 on Google, it pulls it up. It is gigantic. It is a large statute. So be aware. In this slideshow, I'm going to have chunks of it that I'll pull up for people at times. But in general, if you're dealing with ORS 90, that's a couple evenings worth of reading. Back to this Section 6. So you're supposed to give them a copy of the lease, redact various information. Seller will do their best to ensure that the buyer gets a copy of an estoppel certificate. We'll cover those. I'll go into estoppel certificates a little later. And seller will determine a termination, shall deliver a termination notice and any required relocation assistance to the tenant by a date. You'll set a date. Basically say, seller, if you are going to send a termination notice, you're going to send it by this date. If you aren't having the seller send a termination notice, you should be using a different document. That's 4.2 that would go into place if you're not terminating the tenant. So if this form is used when you're going to be terminating a tenant, and you'll set a date where you say, by this day, seller, you are supposed to terminate this contract. You should boot somebody out send them the notice to boot somebody out by this day. That notice should be compliant with the rental agreement. It should be compliant with federal, state, and local laws. Seller will also promptly provide copy of that notice. So the seller should give the buyer a copy of the notice they sent to the tenant so that the buyer then has this evidence that they have followed the rules. They gave the notice to the tenant. They also have paid the relocation assistance and so on and so forth. If seller has some reason to believe before closing, if they have some reason to believe that the tenant is not going to be out by that day, the tenant basically sends them a letter that says, I'm staying here. You are not going to get me out of here unless you wheel me out of here in a gurney. That situation, seller should tell the buyer, because you're going to have some sort of an additional discussion that needs to be done, or an additional negotiation that goes into the process where you say, okay, so, buyer, I know you want this property and you want it without a tenant. We might have a problem here, and it could take a little while to get a forced eviction detainer kind of process going on. Let me know if you're still interested, or we can just switch it over to this being an investment property, and you can just take it with the tenant if it's too much of a hassle. So there's a process of negotiation and a notice that you give at that point. If the tenant is not going to be out by that end of the date, then there are additional rules that will apply, and we'll get to that. One of the other things that this does, it gives the buyer a review period. The Form 7.1 lets the buyer review and gives them a right to terminate if things are not as intended. So, for example, upon receipt of a copy of the rental agreement, termination notice, the evidence of relocation assistance, all those things, and evidence of the time, date, and delivery of the notice, buyer will have a set number of days. The default stance here would be usually 5 business days. You got about a week. To review this information for evidence of compliance, to make sure that the rental agreement, to make sure that the notice of termination, to make sure that the relocation assistance payment, to make sure that the way that you gave the notice to the tenant, to make sure all those things were done right. Because if they were done wrong, you might have a problem where you can't get that tenant out by the time you want to, and the buyer is suddenly becoming an accidental landlord at closing. So make sure you have these things in place, and the buyer has a period of time to review for accuracy, for effectiveness, for just it being done right. And if the buyer sees that things have been done wrong, the buyer has a right during that notice review period to terminate the contract, to say, seller, these things are not correct. This does not work the way it's supposed to. If the buyer does not terminate during that notice review period, they take their time frame to review all the documents, to review the notice, to look at the stuff, and they don't terminate anyways, at that point, we still have the vacancy contingency that applies later on, but that will have its own special rules. In general, if you want to give yourself enough time to review a lease and you're worried about how much review time that could take, you can write in longer periods of time. You could write in 10 business days, 15 business days, something like that. Patrick, I see a question. Sometimes dates can be fluid, like seller shall give notice of termination within 3 days of written notice that appraisal had made value, for example. Should we add something like that in the additional provisions? If you're going to be modifying something to be like to base it off of the appraisal time frame, you should probably put that in the additional provisions. In general, what we would always prefer is when you do ask someone to provide notice of termination, it's on a very distinct day. You want your timelines to be really set in stone and not to have that kind of sway zone where someone goes like, well, you did your appraisal on the 6th. And you said I was supposed to give the notice within 2 days after the 6th, and so that took me up to the 8th. But on the 8th, I decided, I don't really think the 6th counted as one of the days, so technically we were already a day late. You don't want to have those discussions even happen. So putting a hard and fast day down is usually kind of your cleanest way, legally speaking, to protect yourselves. With that said, you can add fluidity in additional provisions. It's just every additional fluidity provision you add is another fault line that can be exploited in a lawsuit later on if things go poorly. The vacancy contingency. This is what we were talking about in this last one. If the buyer's failure to terminate during the notice review period does not release their right to terminate under the vacancy contingency below if selected. So this is the vacancy contingency. This is what the bread and butter of Form 7.1. The vacancy contingency is the way that you can state if you desire that the property needs to be empty by closing. The vacancy contingency, you would check a yes or a no on this box here. You would basically say yes, it needs to be vacant, or no, it doesn't have to be vacant. If you say no, it doesn't have to be vacant, that doesn't mean that the seller doesn't have to terminate. It just means that the termination might only become truly valid after closing has happened. If you have a 90-day notice requirement, that doesn't mean you have to have 90 days out till closing. You can have there's an illustration that'll come up a little later on that it'll make it more clear, but you can have instances where the termination comes after closing. If this transaction is subject to the vacancy contingency, buyer agrees to purchase the property contingent upon tenant having vacated, being out. The buyer should be purchasing the property at closing. There should be nobody in the property and they can just move in. That's the idea behind the vacancy contingency. If closing occurs before the end of the period described in the tenant's termination notice, buyer will have assumed and released the rights, all rights under this vacancy contingency at closing. So the vacancy contingency will carry on after closing. It'll be assumed and to have been released. The buyer then becomes a landlord because that's how this is written. And if tenant remains on the property after the end of the termination date, seller must promptly notify buyer of that happening. So tenant remains on property after the termination date, vacancy contingency has been approved, or even it hasn't been approved, seller needs to let buyer know. This could mean there are multiple instances. One instance where the seller goes, I heard from my tenant, they say they're not leaving. That's a problem. Notice to buyer. And then later on, when the tenant remains on the property at the end of the termination date, the seller should send another notice to the buyer within 2 business days to say, hey, buyer, bad news. The tenant didn't move out. The day they were supposed to be out happened. I tried to terminate them. They're still here. Send the buyer additional notice. So if you have, if it's a week-to-week tenancy, you give them 10 days notice, 10 days pass, you terminate, the tenant doesn't move. At that point, seller should be sending notice to the buyer to let them know we've got a problem. The buyer, if there is a tenant still on the property, will have 2 business days to either terminate the transaction with a refund of the earnest money within the vacancy failure period, or they can renegotiate the terms. So you're supposed to have vacancy at closing. The vacancy didn't happen. Buyer gets 2 days to choose. Do I terminate and just walk, or do we talk it over? Do we figure something out? If the buyer and the seller agree to renegotiate terms in writing, wonderful. That means the buyer has released the vacancy contingency period. You've figured something out. If the buyer doesn't terminate within that 2-day period, or you can write in more days if you need them, that vacancy failure period, if they don't terminate within that vacancy failure period, we're assuming that the buyer has released their right to terminate under the contingency. Essentially, the buyer, if they're really, really worried about this, they will terminate, or they will renegotiate, or they will amend the timeline on this negotiation period. They will give themselves more time. But if the buyer just doesn't care and doesn't respond and doesn't reply, and they get a message from the seller that says, hey, heads up, we got a problem, the tenant didn't move out, and the buyer does nothing, The buyer is becoming a landlord at the end of that process. They were given multiple instances, multiple chances to stop this train, and they just haven't. So the buyer is going to be taking the property with that tenant and becoming a landlord. If there is no vacancy contingency, or if the vacancy contingency is released for whatever reason, this assumption assignment language happens, which is essentially where the buyer and the seller agree that seller's interests in the lease, all of their rights and obligations and responsibilities, those are now the buyer's. They transfer to the buyer. And the buyer will then take on all those rights and responsibilities and liabilities. The buyer takes those on under the lease. Essentially, it says, buyer, you're now the landlord. We're assigning it over to you. If the tenant has paid prepaid rent, they paid like a month in advance, the buyer gets a pro rata share of that prepaid rent. So the seller, if you've got a tenant who paid a month in advance and then you sell the property, the seller doesn't just get to keep a free month's rent. The seller needs to pass pro rata share of that prepaid rent over. Keep in mind the seller also has to pass along the security deposit. That's not in this. That's just Oregon law says, like, whoever's the landlord, they keep the security deposit. So if a seller walks away and doesn't pay you the security deposit, you have a problem, and they should probably have some sort of a dispute or mediation that goes into getting that security deposit from the seller, because that's an issue. When we talk about assignment and assumption, apologies for kind of the childish example here, but this is the best and easiest way to understand it. When you are a landlord, it's a hat. The hat is the hat that gives you all the duties and the privileges of being a landlord. You can collect rent, you can charge fees, late fees potentially, but you also have to keep the property habitable, and you have to repair stuff when it goes wrong. When you assign something by signing an agreement that says, I assign all my duties, and the other person says, I assume all the duties, you move the hat from one person to the next. That is assumption. It moves the rights from one person, the old landlord, to the new landlord. That is the process of assumption, kind of in as simple of a process as we can write it here. This is super fundamental, and it should happen if the buyer is becoming a new landlord, because if they don't assume the lease, somehow you have a seller who's still technically the legal body responsible for the property that they no longer own, and that creates problems. So always do your assignments and your assumptions when you're moving property with a tenant inside it. Now, when we talk about the vacancy addendum, this is kind of an example, an illustration of the tenancy in action. So, for example, landlord here has tenants on the property and sells the property to some new person. With these tenants, they have a lease. The lease is a month-to-month tenancy. It's been going for more than a year, so you need 90-day notice under ORS 90.427.5D. That's the one we talked about earlier, where you say, hey, I'm selling the property to somebody new. The landlord has given these tenants notice within 120 days. Hey, I got an offer. It's great. Here's your 90-day notice. You have two options here. If you said yes to the vacancy contingency, your closing should be 90 or more days out. At that point, once you close the transaction with yes on a vacancy contingency, the property should be vacant at closing. The new owner owns the property and they have no tenants in it. They can just move in at closing. If you said no to the vacancy contingency, you could close within 30 days. At that point, the new landlord, this is the buyer, the new person, this new landlord is going to be a landlord on the property, and they will have the lease assigned to them, and they will be the landlord for 60 or more days. At that point, once 60 more days have passed, you can say 90 days have passed since you got notice, we can terminate this lease. But this new landlord, this buyer, has to be a landlord for a period of time so that 90-day period can pass. So your options in the vacancy contingency are, you can say, yes, we need it vacant, and then your closing date should be well beyond when it's supposed to be vacant. Or you can say, no, we don't need it vacant, and the new buyer just understands that they're going to have tenants. It's going to be some kind of an interesting investment for a little while, but the tenants will be out at some point, and the new landlord can then move into the property. 2 months later, the buyer will then become the owner and the person living in that property. Oh, I'm sorry. Please slow down. I do apologize. It's my old Seattle, Washington roots. We talk fast up there. Ashley asks, would it be better to have the closing date out 90 days so the buyer isn't dealing with becoming the landlord? That is a question for the buyer to answer. If the buyer wants to own the property and doesn't mind being a landlord, then you don't need closing to be 90 days out. If the buyer does really doesn't want to be a landlord at all, at that point, then yeah, you should put the closing date 90 days out or more. It largely is just based on what risk your buyer is willing to take on. If the buyer doesn't mind being a landlord, then no vacancy. If the buyer does mind being a landlord and they just want a house that they can move into, then yeah, you'll want that vacancy contingency in place. But it's a question for the client, not really a question for the broker to necessarily give the client a yes or a no answer on. You should ask them, well, what are you worried about? What are your concerns? We can talk this over. What are you truly concerned about if you were a landlord? And there are real concerns with being a landlord. It's not the easiest job in the world, but at the same time, you'll own a property at that stage, which is sometimes something that's very important to those buyers. Can you do cash for keys to reduce the 90-day period? Cash for keys is a really odd concept that, yes, can be done, but it's a very distinctly difficult situation. Jeremy, if you want to answer that one, the simple answer is cash for keys can be done, but if the tenant does not want to, you can't force it to happen. Tenants can release their own rights under a lease because the rights under law protect the tenant and they can give up their own protections. But there are some instances where cash for keys is considered like a consumer protection violation, and you don't want to accidentally wander your way into like a consumer protections lawsuit because you've bullied a client or a tenant into selling their keys early. Buyer has a big risk of tenants to Buyer has a big risk of tenant to upset the condition of the property when they take over. Yes, so that is one thing that your buyer should be aware. If they are taking a property and the premises is going to have tenants on it, you have the endless risk of a tenant potentially just like kicking holes in the drywall when they get angry at you because it's terminating. That's a concern, and that's one of the main reasons why, if you are becoming a landlord, make sure the security deposit moves over to you. You want to take control of that security deposit because that's the way you pay for damage done to the property. Does the buyer get to inspect the premises prior to closing to make sure the property is not damaged before closing? You would get to inspect the property as a part of the due diligence inspection period, like the due diligence contingency. But the final walkthrough that you would want to do, if you want that, would be something you put in a general addendum on your purchase and sale agreement. That you would generally need some kind of an approval from the tenant, early advance notice to the tenant, because you're a landlord that's technically imposing in on the tenant living space. So if you're going to be checking the property like the day of closing, more than just during the due diligence period where you're allowed to do these various inspections, put it in a general addendum and make sure it's copacetic with ORS 90, because there are certain other requirements of notice to the tenants that need to be done. Keep in mind as well, your mileage may vary by location, very significantly by location. For example, Portland and Milwaukee, Oregon, they require 90-day notice no matter what. There is no such thing as a 30-day notice or termination in the city of Portland if it is a not for cause termination. Municipal codes and local county rules will modify this as well. So at times, you will see that there are some instances where the city will impose some very restrictive standards on landlords. That's going to be something that you'll want to have local specialists be able to explain to you. If you've got a local housing authority or a local landlords association of some sort, or Oregon Rental Housing Association, Multifamily Northwest, those kind of organizations, they can give you more advice and more guidance on specific risks that could be involved in your localities. Now we're going to talk about Form 4.2. So we finished Form 7.1. Now we're going to talk about Form 4.2. This is the investment property addendum. Investment properties are properties that are owned or operated for the purpose of generating income. These are 1 to 4 family dwelling units, commercial properties, multifamily houses like units like apartment complexes, all of these things that are just used for generating income. They have special additional disclosures that we ask people to do in these cases, and it's usually related more to the finances and the efficacy of the actual commercial going concern at that point. So just be aware. If you're doing a transfer of in a commercial property or a property that's just being used to generate income, you're going to use Form 4.2, the investment property addendum. The investment property addendum has diligence, an extra diligence period. During this time frame, the seller, for example, is given the additional disclosures period, 10-ish days. You can set it up as 20 days, you can set it up as 9 days, however many days the parties agree to provide the buyer with all disclosures that they're required to do. We'll get to that disclosure. It's a checklist of documents that the buyer can request. They can say, hey, seller, I want to get copies of all of the certifications that your building has. I want to get the building permit, the parking lot description, the floor plans, whatever it ends up being, they can request those documents. And the seller will then have a set number of days to provide the documents that are requested, or to provide a statement of explanation to say, this is why I don't have the thing. The statements of explanation, for example, there's one that says, you need to provide 6 years of tax documents. The seller can say, I don't, in writing, I don't have 6 years of tax documents. I've only owned the building for 4 years. That statement of explanation, if it is sufficient, that's fine. The buyer is not trying to squeeze blood from a stone right now, so we're not super concerned when your statement of explanation is a reasonable one. If your statement of explanation is, I don't want to give it to you, that's usually not seen as sufficient. At any time when when the buyer has received all these documents, the additional disclosure documents, the buyer gets 10 days to review them and to review the sufficiency of the statements of explanation. And then during that time frame, that 10-day period, the buyer can terminate. So you've given them all the documents you're supposed to, the copies of the leases, the tax statements, the profit loss, that kind of stuff. The buyer gets their 10 days to look it over, and if they don't like it, they can terminate with Form 5.3, which is the notice of termination. They can just go straight termination and say, this is not working out for me. I disapprove. I wish to terminate. During this investment diligence period, the parties can negotiate for various repairs or corrections or modifications to the purchase price that they deem necessary. If the buyer terminates during the investment diligence period, earnest money goes back to the buyer. We have a question. Does the buyer get to inspect the premises prior to closing to make sure that the property is not damaged before closing? I think I answered that one, actually. Sorry, Jeremy, you're doing a great job on there. I'm just not paying attention to chat very closely. What this means is seller has a period of time to deliver all the documents, and then buyer has a period of time to review them. If buyer doesn't like them, buyer can terminate. These are the things where, for example, you get a lease and you go, this is insane. This tenant has total control over this arrangement. I disagree with this. Or a weird situation where the tenant has asked for the landlord to be an additional insured or something like that. These things happen. And when they do happen, a tenant doesn't necessarily want to be the one the new landlord doesn't necessarily want to be involved, and they have a right to terminate or renegotiate, or to even ask for various repairs or changes if there are things that are hanging in the process. The actual Section 11, this is the documents for the additional disclosures. It's broken up into 5 sections. The buyer can request rental information, financial information, property information, legal information, and business information. I've expanded out the section for property information. If you look on the actual form, each one of those is a much larger section. You see it jumps from line 47 to 54, from 54 to 62, 62, 72, 72, 81. So there's quite a healthy space that's just these checkboxes. But in Section C, you can see the various checkboxes. So for example, a list of your capital expenditures, renovations, repairs, and landscaping projects that cost more than $5,000 completed in the last 6 years. If you haven't had anything done in the last 6 years, or if you, for example, say, I haven't owned the property for 6 years, I can give you 4 years worth, then that's a statement of explanation, no problem. Copies of various engineering reports, copies of appraisals, copies of, if you've got green certifications, sometimes that's important to the buyers. They want to know if it's a LEED certified, LEED platinum building, something like that. That can be important. And so the buyer can request documents, and then the seller should provide the requested documents or explain why they can't provide the requested documents. If the seller needs more time, they can ask for it. That's always allowed. So the buyer and the seller is Section 5. Buyer and seller may agree in writing to an extension of the additional disclosures period or the investment diligence period. The buyer and the seller shall not unreasonably withhold approval for that extension. So if the seller says, look, I need a couple more days, my architect can't get the floor plan to you until Monday, the buyer should not be blockading that. If the seller says my architect can't get it to you until they're done with their vacation 3 months from now, that would be unreasonable, and the buyer could reasonably be the one that withholds approval of that extension. Those delays or obstacles, they happen, and have some grace. Understand that sometimes there can be delays in the process. Sometimes a ship gets lodged in the Suez Canal and problems happen. Section 6 is the release of the investment diligence contingency. If the buyer fails to terminate the contract during their period of review time, that 10 days the buyer has to review the documents, we consider the buyer as having released the right to terminate. They no longer can terminate. So buyers, once you get all the documents, you have 10 days to look it over. If you don't like it, terminate within those 10 days or negotiate an extension to your investment diligence period. But you should do one of those two things. You should either terminate or figure it out within that time frame. So if the seller does get the documents to the buyer and 10 days pass, they can let out a breath, because the buyer is not terminating based on the documents that were received. It gives the parties kind of an ability to understand the process is still chugging along with the transaction. Furthermore, there are some other costs that may be included in this. So if the seller is obtaining various additional disclosure statements, they have to contact the people to do lead and pay $5 to get the certificate printed off or something like that. The seller is responsible for the costs of obtaining additional disclosure documents. The buyer, on the other hand, is going to be responsible for all of the review or the extras or the additional costs incurred in obtaining other stuff or additional stuff. So if the buyer says, I want something else special, I want a very distinct document that's not on the list, buyer pays the cost of obtaining that distinct specialized other property. If the seller fails to provide the documents or statements of explanation, if they can't provide those documents, then the buyer gets a chance to send a notice of termination within 2 days of that period of time, like the additional disclosures period. So seller has 10 days. You can write it in for more time if seller needs more time. Seller does not comply. They can't give you the right documents, fails to provide all the things they're supposed to. At that point, at the end of the additional disclosures period, the buyer can say, look, seller, I asked you to provide the profit loss statements and you didn't. I'm terminating the contract. It's over because you did not provide the documents that were expressly requested. So the buyer has a chance, if the documents are not delivered on time, the proper documents are not delivered, the buyer has an out. They can say, you did not give me the things I need to see. There is a confidentiality provision. Like we said earlier, we're being a little more bullish on confidentiality just to avoid the outsized lawsuits that can exist. Seller shall redact all personally identifying information. All documents and written additional disclosure information provided to buyer shall be deemed to be confidential for all purposes. If the sales agreement is terminated, expires, or closes, buyer shall promptly return all additional disclosure documents and shall destroy any copies, notes, or records derived from those documents. So the buyer does not, if you terminate your transaction, the buyer doesn't get to keep the certificate as a souvenir or keep the architect's floor plans as a souvenir. That's not how it works. If the buyer discloses or causes any kind of a disclosure of confidential information that causes a lawsuit, buyer may be responsible for the damages that the seller suffers. Now, this is a full redaction provision. It is a very restrictive one. The parties can waive or agree to limit or cabin in these decisions, the redaction or the confidentiality provisions, but that should be an express decision that we have parties make in this case. So if you're a seller for a buyer that says, well, I want to know the names of all the tenants in this property, you can ask for that. You can put it in writing and say, we'd really like to see the tenants' names. We're gonna waive. I agree to waive the personal identifying information of the tenant names. That seems reasonable to me. You can ask for it, and if that is agreed to by the parties, then that's fine. Go ahead. You can release that information, but as a default stance, we're trying to under disclose rather than over disclose. You can ask for over-disclosure, but we really don't advise it in general. Be cautious with what information that you send out because lawsuits are getting kind of far and wide at these points for confidential information. So that's the confidentiality provision. Now, we also have an assignment and assumption provision. You remember this one? I didn't put the hat on this one, but this is the same concept. If you are agreeing to this agreement, the buyer is taking on the landlord rights, and the seller is giving the buyer the landlord rights and responsibilities. It's great. It's wonderful. If you have paid prepaid rent or there's been some prepayment of an installment, then that should also be passed along pro rata to the new landlord, the buyer. Seller will assign and buyer will assume that stuff. They should do it promptly. This should be as soon as possible, but no more than 2 business days. So, they should assign that. Seller should promptly tell the tenants about that assignment. So when you assign this thing, when you execute the addendum, seller needs to say, hey, by the way, tenant, someone else is going to be your landlord pretty soon. Heads up. And that should be done pretty quick. If the deal is terminated for whatever reason, this assumption and assignment does not become valid. This assumption and assignment is only effective upon successful closing of the sales agreement. So if you do not successfully close the sales agreement, the assignment and assumption language never goes off, never happens. So be aware. Assignment and assumption it should happen. It'll happen upon closing when you've signed this agreement. But if your closing falls apart, you didn't accidentally make the buyer the landlord. It wasn't a unilateral change of rights. The rights only come into effect upon closing. Seller will pay that pro rata rent. Make sure that happens. You don't want buyers to ask the tenant for rent and the tenant to say, well, I already paid it, because the buyer is entitled to the ownership right, the rent that comes from this property. This is an example of what can happen if you have an investment and a tenancy vacancy that happens simultaneously. A duplex that has two tenants in it, for example. The example would be the buyer purchases the property and wants to move into the blue unit, doesn't care about the red unit. The buyer moving into the blue unit would use Form 7.1, and they would vacate their tenants out and then take possession of the blue unit and move in. And the red unit, you would use Form 4.2, and you would turn that into an investment property, because that is then a lease that you have with the tenants in that red unit. So you can do both at once. It's not like a monodimensional process. If you have a unit that is comprised of multiple dwellings, you can have instances of multiple investment properties or multiple tenancy vacancy addendums that get signed simultaneously. Do you need to create a new contract for that short time frame? Jacqueline, I'm not certain what you mean by the short time frame. If you could pop more detail into the Q&A, I'll have Jeremy answer that one. But because I don't want to run people over long on this one, and I think I might keep you here a little longer than I planned, we're going to keep running along as Jeremy answers questions in chat if he can. So we're going to talk about the estoppel certificate next. This is Form 7.2. What is an estoppel certificate? These are legal documents that acknowledge and basically they're affidavits of the terms of a lease against possible claims and of possible claims or against possible claims against the landlord. These are designed to be used when property is exchanging hands with a lease. The real use case, like a place where people really want an estoppel certificate, is when a lease is oral. The parties just agreed that you would be renting the space but never wrote anything down, or when lease documents have been lost or damaged. In those cases where your record of the information is gone, you want an estoppel certificate, because sometimes memory does not match reality. And that's a problem. If the landlord moves in, the buyer moves in, and they've understood that it was $1,000 a month, and the tenant says, no, it's been $600 a month every single month, you can't just charge the tenant $1,000 and sue them for the difference if you have no documentation or evidence to back it up. You would have a serious problem of lawsuit if that turns out to be that actually it was $600 a month. Sorry, you just charged the tenant way too much money and you did it because you didn't know. That's a lawsuit you don't want to be a part of. So an estoppel certificate ensures that you have something in writing to back up oral or lost leases that didn't exist before. The estoppel certificate is filled out by the tenant to the best of the tenant's knowledge. It has very important information that the landlord wants to know, the buyer landlord, the move-in landlord needs to know, such as when does the lease end? Has the lease ever been modified? That's hugely important. You want to know if it's been amended, because if there was an amendment and it changed a very fundamental policy of that contract, you need to know how to change that. Other things, for example, has the tenant been given a right to sublet the property? If that's the case, you should know, because the person in the building might not be the tenant on the lease, and that's a problem if you don't know about it. So this estoppel certificate provides you with very fundamental information that you need to know when you are becoming a landlord. It also has other information that can be very important, such as, did the tenant prepay rent? That's important. Is there a security deposit? Was a part of the security deposit already used on repairs? If that's the case, the new buyer should know, because when they move in and they look at the lease and they say, it says you're supposed to have a $2,000 security deposit. I only got $1,200. Why? That's a problem, because you need to know that you've already drained some of your security deposit. You're taking control of the property with less than the expected amount of security. Other things that are important is their personal property the landlord's going to take with them. Is there an improvement that the landlord promised to make that they haven't finished yet? Because when the buyer takes over as the landlord, they have to make that improvement. They were supposed to do that. If a landlord signs some silly written agreement that says, no worries, tenant, I am absolutely going to replace the windows with the most expensive thing on the market. Buyer, beware. You might have to put the most expensive window on the market into your property, because that was something that was signed and agreed to with the landlord and the tenant on that process. And you want to know about these things in advance. That's what the estoppel certificate is there for. It protects both the tenant and the buyer. The buyer can use it as a sword in court if they want to. They can use it to guarantee terms of the lease and defend themselves, the terms in this tenant estoppel certificate. They can use it to inquire into areas where the landlord or the lease and landlord's lease and the tenant's understanding of the lease are different, where the tenant says, yeah, there was an amendment to this lease, and the landlord says, I don't remember any leases. You should know about that, and you really want to know about that because it's important. Those are important factors. You can use it to say when you've got, for example, if you've learned about pending liens, or if you learn that some tenant is going to be very difficult, you can learn about that at the estoppel stage at the start before you've gotten like sold the property and you are now a landlord. You can learn these things. Can a new owner ask for an additional security deposit? Colleen, I don't believe so, but that's one that, Jeremy, if you can answer that one from the ORS 90s, I do not recall. I don't think you can, but I can't back that up with absolute guarantees. I'd have to look at the statute itself. The other area where this is relevant is the shield use of the estoppel certificate. A tenant can guarantee the terms of a lease using the estoppel certificate. They can also ensure that the new landlord knows about unique conditions or entitlements. If the landlord agreed that this tenant can keep 3 pets on the property because they're small dogs rather than 1 giant mastiff or something like that, they should know about that, and you should write that into the upcoming lease with this estoppel certificate. The tenant can also use it to ensure that security deposits, prepayments, and all those things, they are honored, they're disclosed, and they are transferred. It's used for both the tenant and the buyer. It might seem like it's being used to really squish a tenant into a term. It might seem like it's being used to just smash a buyer into having to follow the terms of the previous lease. It's really used for both of them, and it depends on what the information is to really get you an answer on how to use the estoppel certificate. If you have a mismatch between the estoppel certificate and the lease, for example, the tenant says, well, here's my understanding, it was a $600 a month lease. And then the landlord can send you a copy of the lease that says, no, it's $1,000. At that point, talk to the tenant, show them the lease and say, well, the lease says $1,000 a month. Where is this 600 coming from? If that 600, if the tenant can back it up with like, well, here's an amendment that said $600 a month. Well, now you've got something to discuss with that landlord, but it gives you an ability to kind of pause things and say, okay, hold on, everybody. We got a discrepancy that we need to figure out. The estoppel certificate lets you catch those discrepancies. If there is no lease document and the landlord and tenant dispute something, make sure you get that figured out now. If there is a dispute and the tenant just refuses to adhere to what the lease says, the estoppel certificate does not overpower a written lease. So if the landlord gave you the lease and the tenant's understanding of the lease through the estoppel certificate is not the same, the lease still controls. But if you have no lease, this gives you a chance to discuss things, to figure it out. The last thing we're going to talk about here is the agricultural tenant addendum. This is Form 7.4. It's somewhat specialized. It's kind of the same as what we've seen before, but I'll show you the special points in it. The limited use of this is when the form is used by a buyer to purchase agricultural property that is subject to an existing lease for commercial agriculture or extraction. So someone is farming the land as a tenant farmer. Or when the seller intends to rent the property from the buyer for commercial agriculture or extraction purposes. The seller is selling the farm, but they want to ranch it still because they've been ranching it for their entire lives. You can sell a property and then immediately become a tenant farmer. That's okay. Or, and those are the two situations for this one. The thing with this agricultural tenant addendum is it's meant to transfer the landlord rights in the agricultural lease, which are specialized under Oregon law. The agricultural rights in Oregon are very unique, and they have additional protections, and in some cases, fewer protections in some cases. We'll point those out. But this is used when you're transferring agricultural land that is either currently being used for commercial extraction or agriculture, or planned to be used by the seller for commercial extraction or agriculture. It's not a replacement for legal advice. So, consult a lawyer if your client wants more advice on this one. The limited use of it, ORS 90-110-9. This is the Residential Landlord Tenant Act from Oregon law. It expressly excludes occupancy under a rental agreement covering premises used by the occupant primarily for agricultural purposes. So that means if it is if you're renting the whole farm and the farmhouse all at once to run your farm, landlord-tenant law doesn't apply. If you have two separate documents, one lease that lets you rent the farm and one lease that lets you rent the farmhouse, that farmhouse lease is Residential Landlord Tenant Act. Form 7.1 or 4.2 goes into that one. But the farm itself, that separate agricultural one, that's its own separate document. So be aware, depending on the usage of the form. Oh, Jeremy's hopping off for the open house. Thank you so much, Jeremy. I appreciate all your support. This is meant to be used in those cases where you have a farm where the primary usage of this the lease is to cover agriculture or extraction, to cover something that is like a commercial extractive agricultural enterprise that is separate from just a purely residential living on that property kind of lease. The document itself has various information that you provide, general information about the tenant if it's got a tenant. It's got various representations that the seller is agreeing. They're basically saying, yep, the lease is valid. It hasn't been modified, or if it has been modified, you've seen those addendums. It has my interest in the lease is not encumbered by anything. I can transfer it across to you. The seller is able to transfer those things. They have the ability to do these kind of things. The lien is not encumbered. There's no bank that has like a partial ownership over things in this case. And there are no sums owing or due under this lease. If the seller, for some reason, agreed to, I don't know, install irrigation tiles in the ground or something like that, the seller should let the buyer know before they assign this lease, because that agreement, that encumbrance, that sum, that like payment for those irrigation tiles, that is something that transfers over to the buyer. So you need to let them know. And in this case, we say, look, seller, if you have sums or due or owing, if there's an expense that you owe, before you transfer the ag lease, pay it off. Pay all those things off. Maybe pay them off at closing, but pay them off. It shouldn't be something, the buyer should be getting a lien or the lease essentially free and clear of further encumbrances or expenditures. You can amend this. You can put a general addendum on this that says, all right, buyer's taking on the price of fixing the tiling and the irrigation, but you don't have to. It has the assignment language. You'll note the little hat's moving again. I know it's a trite example, but it's really a clean one to explain how this thing works. The old tenant, the seller, landlord, the seller, moves the rights over to the buyer. And if you've got some sort of an expense that is incurred in connection to this assignment or in connection to creating the lease for this property, that will be covered by the seller. The buyer has a right, and this is a specialized one here, and the reason why this specialized right exists here but not elsewhere, the buyer has a right anytime before closing to request that the seller terminates the agricultural lease with the tenant. The buyer can say, seller, I want the tenant gone. I want to have a farm with nobody on it. I want to be able to farm my own land. I want to have nobody here. You can do that because termination of a farm tenancy is permitted under ORS 91. It's not a residential landlord-tenant law situation. It's a termination of tenancy situation, which is separate. And that allows you to essentially terminate a lease without the same requirements in place, the same notice, the same express, relocation assistance, all those things. So because it's a much more loosey-goosey way of terminating a contract, we allow the buyer to make a request of the seller to say, look, I want the tenant gone. I want to own this property. I want to have be the one farming it. I want it to be mine. You can do that. However, if the buyer does it wrong, they need to acknowledge that the seller might not be able to terminate it. Their lease might prevent this. They might not be able to terminate before closing, or they might not be able to, terminating it early might cause some serious fines or fees. In some cases, leases will have something that says, if you terminate this lease like a month before it's supposed to close, you owe me $10,000 because this is my livelihood. That early termination fee, the buyer is going to eat those costs. So be aware, buyers, you can ask for a termination of the tenant, like the agriculture tenant's lease, but you're going to pay for any of the expenses that come with that. So don't necessarily always just terminate that tenant because you want the farm. We do request that the seller provide the various lease documents. This is going to either be a copy of the lease with the agricultural tenant or a copy of the draft seller-buyer lease agreement. So if the seller is moving into they sold the ranch and now they're going to start ranching it as a tenant farmer, the seller has a couple days to give the buyer a copy of the draft lease to say, this is the terms that I would like to have on our lease. Do you like it? And the various other documents that are attended to that. So the seller has to give them like the fundamental documents that would create this tenancy after closing. If the seller does not do this, the buyer can send a notice of default. They can say, seller, you had 5 days. Where are the forms? They give them an extra 3 or 4 days to fix it. If they don't fix it, they can terminate and earnest money goes to the buyer. So the seller is given a couple days, a handful of days to provide various documents. They should provide those documents. If they don't, buyer can send in a notice of default and potentially terminate if that default is not cured. The buyer then, once they get these documents, they have a period of time to review the lease. They get 5-ish days. You can set it up for more than 5 if you want. They get 5 days to review the lease documents and negotiate changes to the documents. If they're lease documents with the seller, you can negotiate those. You can technically try and negotiate with the tenant, but you're not going to get much there. During this period, you can try and do that, or you can terminate. If you're a buyer and you get the lease documents, you get 5 days to figure it out or terminate the contract because you can't figure it out. If you do not terminate during that agricultural lease review period, the buyer does not get a chance to terminate anymore. They've released the right to terminate. They're just taking this property and assuming the tenancy at closing. So you get a period of time to look it over. You get a period of time to review it. You get a period of time to terminate. That's with that look over and review period. If you don't terminate during that time frame, congratulations, you're now an agricultural landlord. There's also a very specialized provision which has to be in these agricultural tenancy things that is about crop harvest. ORS 91.230 states that a tenant or person in possession shall, after termination of the lease or occupancy, have free access to the premises to cultivate, harvest, and gather any crop or produce of the soil planted or sown by the tenant or person in possession before the service of notice to quit. So that means if I'm a tenant on a property and I plant corn, let's say on April 1st, I plant my corn. My lease is terminated on May 1st. I can't go back on the property. I can't live in the farmhouse anymore, but I can come back and harvest. I can weed. I can water. I can take that, like, until I've gotten all my corn off that property. I can keep going back on specifically to take care of my crop. That is a super distinct protection that exists here, and you need to have those in place because Oregon law provides that protection. That is the right to emblements. It's a significant one. Be aware that's kind of the main reason behind the agricultural process and the reason why there's a farm and ranch form as well as the agricultural tenant documents. That's the presentation. I've kept you guys 4 minutes longer than we were planning at the start. I appreciate all the attention and the questions. I see a question in the chat. I would specifically appreciate copies of a few demonstration slides you have on assignment or assumption, estoppel and agriculture. Great. Katie, let's send this thing out. Let's see if we can send slides out to people afterwards who attended. If you've got questions, toss them up in chat. This is the time to ask them or to question on these things. If not, we hope that this is informative and helpful and that everyone is feeling good about the idea of potentially having tenants transfer through the property. We appreciate everyone taking the time. I see a hand up. If you want to, I don't know, Katie, do we have a way of allowing people to unmute, or does that have to be answered in the question and answer area? Okay, go ahead. I believe it's Iraj. If you want to unmute and then ask a question. If people want to have a double dose of forms training, you can also go over to the open house. Oh, you're unmuted. Go ahead. What's the question?
Yeah, the question is who's filling the stopper certificates for the tenants? Because a lot of questions. Is the landlord first give it to tenant to approve and sign, or you have to give it to the tenant to fill in the rent, the rate, whatever? So
Getting no audio from you on this one. It might be easier to type it in the Q&A. It could be an audio issue on my side, or it could be a microphone issue on your side. I'm not sure which one. You guys get okay. That's bizarre. Okay, go ahead again.
okay.
Well, I got you this time. Okay.
Sure. The question is who's filling the forms, stopper forms for the tenant? Is the landlord supposed to do it, give it to tenants for approval, or the tenant is going to? Because
the landlord should be the one providing. So usually it's the landlord that will provide the estoppel form to the tenant. That's one of the kind of requirements of the forms. If the landlord doesn't provide it, as a buyer's agent, you wouldn't be wrong to send an estoppel certificate to the tenant. But in general, we would say if you're a buyer's agent who's looking to become the landlord, you don't have any connection to that tenant. So don't contact them unless you've gotten approval. The landlord can contact the tenant because there's a privity there that they're not kind of overstepping themselves. So usually the landlord, the seller, should be the one sending estoppel stuff.
Okay, thank you.
Yep. Apologies on the audio problem on my end.
Sure.
Any other questions by people? Otherwise, that's the training as we've got it. We'll try and send stuff out to people relatively soon. Oh, can the tenant fill out the estoppel certificate and have the tenant sign? The estoppel certificate should be filled out to the best of the tenant's knowledge. So if a landlord fills it out and hands it to them and the tenant signs it, legally speaking, the tenant would then be ratifying the information, which means they're saying, this is to the best of my knowledge. But the tenant would always have an argument they could bring in court that says, I don't believe this was actually accurate because they just handed it to me to sign it. And how was I supposed to know I was supposed to change the terms on it? So in general, best case scenario, best practice would be handing the tenant a blank estoppel certificate and saying, can you write in the terms of the lease as you understand them? Because or if you're fine with it, we can just send the lease across to the person and say that's fine. But the estoppel certificate is there to kind of lock it in based on how the tenant understands the terms. And with that, I think that's our presentation. If people have questions, slippery slope. It is. At this point, if you got questions, we advise if you still want to like pop more questions, you something pops up later on, you have a burning question you really want to ask us. Forms@OregonRealtors.org or legal@OregonRealtors.org. You can send us an email and we'll do our best to respond to the questions that pop up. Our goal is that any questions people have related to the forms or just related to legal concepts in general at this point, we will be able to provide you an accurate, legally sound answer that is that will assist your practice and keep you out of kind of legally hot water if something does go wrong. With that, though, that's our training. I believe, Katie, there's something about CE certificates will be sent out is it within a week, 5 days, 7 days? I don't know what the exact state, after having been on so many of these, 2 weeks. The CE certificates should be sent out within the next 2 weeks. We'll do our best to get those to you as soon as possible. So thank you, everyone.